President Trump's tariff blocked by a U.S. court, which declared them illegal and throws his tariff strategy into turmoil. The ruling could eliminate new tariffs on imports from China, Canada, Mexico, and other countries, but the Trump administration has said it will appeal the ruling. Here to break down what you need to know is Yahoo Finance legal correspondent Alexis Keenan. Alexis, this all started with the invocation of the International Emergency Economic Powers Act here.
Yeah.
Where do things stand now?
So this is a tremendous ruling by this court coming down late last night. And what the three-judge panel in Manhattan said at the International Trade Court is that the law that Trump relied on, that you just referenced there, the IEEPA, that's the International Economic Emergency Powers Act, it's a 1977 law, that it does not support the type of what the court called unbounded tariffs that come in President Trump's executive orders since he took office in January. They said that type of authority, that must come from Congress. Now, this law is meant to address unusual and extraordinary threats to national security. That is after the president would declare a national emergency. But the court here is saying, no, the type of emergencies that the Trump administration has put forward are not good enough to satisfy this law. And those specifically, if you remember, were trade deficits, the flow of illegal drugs, and the flow of illegal immigration. Now, in a response, the White House has said, made this kind of balance of power statement. That's what this case is about. The White House saying these deficits have created a national emergency that has decimated American communities, left our workers behind, and weakened our defense industrial base. Facts that the court did not dispute. It is not for unelected judges, they say, to decide how to properly address a national emergency. So the Trump administration there is saying that that is the job of the executive, and that's much of what this case was disputing here. Now, let's briefly take a look at the tariffs that are impacted. It's most of the tariffs that have been applied since January. So that 10% baseline tariff on all imports to the U.S., also the 25% tariff on all imports from Canada and Mexico, except for some steel and aluminum tariffs that aren't applying here. Also, those were under a pause as well. So in addition, the 30% tariff that was also pending against China, also on a pause there, as well as these reciprocal tariffs that build on top of those 10% baseline tariffs. The Trump administration has already immediately filed a notice of appeal. They have about 30 days to file if they want to do that. And where this case would go next is the U.S. Court of Appeals for the Federal Circuit. They're the ones who would take up this matter from here.
Let's talk about that then, Alexis, because two things stick out to me. Reading through the document this morning, they basically give President Trump the playbook here. They talk about Section 122 potentially being a better fit than IEEPA. So could he utilize that to get around any pushback from those appellate courts, from the Supreme Court on his tariffs?
That's what we would expect. Now, in the oral arguments for this case, there were a lot of questions from the judicial panel saying, well, where do we draw the line exactly? How far does IEEPA extend? Give us some parameters, lawyers who are arguing on behalf of your clients. Tell us where to go. Now, in this decision, that doesn't exist, right? There's not a hard line. It's more of the judges saying, well, whatever Trump's administration did to justify, there's not a tight enough nexus between addressing the national security and the tariffs, that they are not a perfect fit. So yes, we would expect to see those types of arguments come through. Another really interesting aspect that I saw in a Politico story this morning is that the idea that the government may have to pay back tariffs to countries where tariffs have already been assessed, so that could come at a big expense as well.
Always so much to cover. I also thought it was interesting, the judges behind this, too, very mixed when it comes to political background, which is interesting given.
Yes, but yet a unanimous decision here.
Absolutely. Really important context, Alexis. Thank you. We've got Greta Peisch. She is a partner at Wiley, Rein, and as well a former general counsel at the Office of the United States Trade Representative. We also still have Paul with us for the conversation. Greta, it's fantastic to get your insights this morning because we are all looking for clarity on what this is going to mean for U.S. trade policy going forward. What is your take on what this ruling means for Trump's tariffs?
Well, I would agree with the analysis that you've cited. It's a setback. It is a ruling that this authority that the president has relied on, the International Emergency Economic Powers Act, or IEEPA, can't be used in this way for these tariffs. It doesn't mean that the president can't find other means or authorities to try to implement this policy. And it's also just the first step in litigation. The administration has already filed a motion to stay or sort of pause the order, and has filed a motion to appeal. So this is certainly going to see further fights in the courts, which creates uncertainty as to whether this ruling will hold. But at the same time, the administration is certainly looking at other avenues to pursue the policy that the president seems to be really dedicated to.
Yeah, so Greta, where do you see this sort of netting out? Do you see the administration being successful in its attempts at further litigation, or do you see them successfully getting their tariffs through other measures like Section 122, which was suggested to the administration in the ruling?
Well, they're certainly going to pursue both avenues. And in the short term, it may be that they use Section 122 that you mentioned in order to displace the tariffs that have been removed, particularly those worldwide tariffs that were set at least currently at 10%. And then at the same time, continue to pursue the courts and try to make their case that, in fact, the IEEPA does allow the types of tariffs that have been imposed. And I think, as Paul mentioned, a third option is to look to Congress. Of course, Congress is considering the reconciliation bill right now, where tax budget issues are on the table. Could the president put before Congress ideas to expand tariff authorities or put in place some of the pieces of his tariff agenda? Possibly.
Mm-hmm. And Greta, my co-host for the hour, Paul Grunwald, has a question for you.
Yeah, I think, Greta, you partially answered it. I was going to ask you, what's the likelihood that some of this actually migrates into Congress? If the president's able to invoke IEEPA, he's got control of the negotiations. But if Congress actually passes the tariff, then I guess they would lose some of that. So how likely do you think that is, that we get some tariff action in the Congress? Or do you think this is going to stay mostly with the executive branch?
Well, I think it's, at the end of the day, I think the political calculus is that it would be a really uphill battle even to get all Republicans on board with expanding tariff authority or putting new tariffs in place, right? That's going to be controversial. You have Republican members of Congress who've expressed concerns about the tariff and the tariff policies to date. Now, that doesn't mean that the president won't test and pursue whether there's an openness in Congress to doing so. And I think, I would just say that to your question about sort of ceding that authority to Congress, there's probably lots of different legislative scenarios you could think of. Certainly, Congress could itself put a 10% tariff in place. It could also put a tariff in place and then leave some discretion through a new statutory authority for the president to raise or lower their tariffs.
And Greta, I also want to get your take on this from a negotiation perspective as a former U.S. trade representative yourself. What does a ruling like this do to the president's negotiating power?
Well, I think that the administration, one reason that they're going to look rapidly at near-term solutions to reinstate or put back in place these tariffs is to retain that negotiating leverage. This is a key trade policy objective of the president. And so even if the tools that they look at are slower or have some restrictions that weren't in place with the tariffs that have been vacated, they want to at least put the threat of tariffs back on the table for these negotiating partners that they've been talking to.
And in terms of how a ruling like this kind of impacts those negotiations, again, as we've sort of heard of like phone calls going back and forth, maybe not, between the administration and several of these countries he announced so-called reciprocal tariffs on April 2nd. Are those phone calls going to start drying up off the back of this ruling?
Well, I don't think so, because I think that trading partners also know that this is the administration has other options, and that this is a policy that the president is determined to pursue. Also, of course, there are tariffs in place that the ruling does not impact. These are the sectoral tariffs, so on steel, aluminum, autos, investigations that are ongoing on pharmaceutical products, semiconductor products, and goods that contain those products. And so we saw some of the outcomes of the UK negotiations addressing, for example, the auto tariffs and making reference to some of those other sectoral actions. So there are there's still negotiations to be had. There are still tariffs in place. And again, there's still the potential threat of new tariffs using other authorities.
Yeah, Greta, and I guess the other thing we're hearing is with some of the trading partners, I'm thinking of some of the Asian partners like Japan and Korea, some of the deal could be they buy more, U.S. Energy products, or they buy more, pharma, or they might buy more planes from Boeing. So it doesn't necessarily have to be all tariff related when we're putting together these deals. Is that your view as well?
Yes, that's been a part of what the administration has been looking for. It seems like as an outcome of these deals, right, we see tariffs on the table. We see potentially non-tariff barriers, whether that's regulatory or other tax barriers. And as you said, sort of purchase commitments or investments, right? So there's been a broader set of asks and pieces on the negotiating table that the administration has been working with.
Greta, really appreciate your insights, and thank you so much, Paul, for the great questions as well. Appreciate you both.